She's not looking out for the interest of our boys. If she was looking out for the best interest of our boys, she would not have moved Ben and Sam to Kansas. That was
Monica O'Rourke, bravo. I think you were the one that precipitated the conducting of this hearing. What relief are you seeking? You're muted.
Thank you. The hearing process in California came to a conclusion on June 20th. New orders were instated on June 20th of this year. I'm requesting that the new orders be recorded. And also, now that there are no pending cases in California, that jurisdiction again be reviewed with the intent of having the jurisdiction of this case moved to Kansas. The argument for that is that the current new orders, line item 3.02 state, commencing with the date of the signing of this court order, the children shall reside primarily with the mother in Butler County, Kansas. Noting that the children's primary residence and state of residence remains in Butler County, Kansas. And so under the UCCJA, I am requesting that a subsequent judicial review occur with the intent of change of jurisdiction to Kansas.
All right. Let me address Mr. Bravo Hernandez at this time. Are you opposing the relief that's being sought here?
Absolutely 100%. We just got done with a court hearing like a week ago or a week and a half ago. And I feel like we're back to square one. The California court did not release jurisdiction. There's a reason why, because they have more background information on the situation. And it is my intention to try to get this move away order removed and hopefully bring my kids back to California where they're supposed to be located.
But wasn't that addressed at this last hearing in June? In the specifics of where the children are living now,
right,
and where they're going to be, seems to have already been submitted to the California court and resolved in essentially the mother's favor. Wouldn't you agree?
Yeah, it was they granted that move away order, but it is my I don't know. I'm gonna try to take any and every route that I can to try to get the California court to somehow remove this move away order, because it was granted under circumstances that should not have been granted. But they did this last court hearing. They did grant me custody in this situation, and I am attempting to gain more custody of my sons. This situation is it has way more background information, and I understand that there's legal proceeding and stuff, but I want to be involved in my son's life, and what Ms. O'Rourke is attempting to do is cut me out completely. The schedule that she's attempting to push in this situation is not something that's workable for both of us. Obviously, it is important for a parent to be involved in their son's lives. And what Ms. O'Rourke is trying to do is she's trying to cut me out completely, because as we all know, we all work and we have employment, and the schedule sometimes is not what Ms. O'Rourke is proposing is just not something that is good for my schedule, my work schedule, for my life schedule. It's not something that is flexible, and that's something that Ms. O'Rourke should have taken into account when she removed our kids out of the state. And hopefully the court does not grant her the ability to do that, because she will cut me out completely out of my son's life, and that's what she's been doing the last 6-7 years.
Again, are you suggesting that this court should change the orders that were made in California?
No, I'm proposing that the order that California just granted me to leave those orders and let it stay. And I'm not really sure how. I know the last time you met with a judge here in California, and I think the last situation that I heard was that California would keep jurisdiction of the court hearing, so we wouldn't have to go back and forth through the.
Monica Bravo's trying to move the whole custody case to Kansas, and the judge isn't wasting any time digging into why. With legal forms,
Kansas and California court, it is kind of stressful to have two different courts dealing with this situation, at the same time.
This court really isn't dealing with it up to this point.
Okay.
This court deferred to the California courts,
Right.
handling the case at the trial level for this hearing that you conducted in June.
Right.
I don't think that it would constitute a permanent relinquishment of child custody jurisdiction, but only for purposes of the fact that we had contested matters potentially pending in two different courts at the same time in different states. California decided to keep jurisdiction for purposes of the trial which just took place, which issues were presented to that court and resolved in some ways against you as the father of the children. And I recognize that you may be dissatisfied with the rulings made by the California court, but
Actually, in my favor. The last situation was in my favor, and it's been probably about 6 years since I've had a decision in my favor, and so that's why I am in agreement with the California court in terms of the parental situation that they kicked out, because I honestly feel like it's more important for my sons to be around me than mom's been around them for quite a while the last few years.
right. So you think that the California ruling that was made in June is favorable to you?
Absolutely. Compared to actually not the June order, it was like early July, I want to say. Dang, has it been that way? I think it's been like the early July, maybe late June. But yeah, they ruled in my favor to keep the current custody order, which so I have to complete 6 different visits out to Kansas, and in August I already scheduled my visit to go see the boys on August the 21st to the 23rd, and then the California court agreed that they should be sent to California during the times that they gave us like 9 different dates or something, where the boys will be sent out to California, and we'll both be responsible for covering the cost of those visits.
All right, let me make sure I understand what I'm looking at here. I see an order of child custody and parenting time filed 6/20 of 2025, but the hearing date is listed at 1/15 of 25. Is that not the most recent order that was entered in the California court?
That is the most recent order. The original and temporary orders, this order was put into, I'm sorry, can you hold on just a second? Sorry about that. Someone just like barged into this room. So we had, the original hearing was on January 15th. The orders that are before you were put into temporary place on January 15th. And then a subsequent hearing was had on June 20th to review whether or not the temporary orders would be made permanent. On June 20th, the January 15th orders that were temporary were made permanent. These orders are that the children reside primarily in Kansas and visit California about every other month during the year. I'm not contesting these orders. What Mr. Hernandez is referring to in terms of the move away order was an order that was put in place 2 years ago, 3 years ago now. I think it was almost 3 years ago now. No, 2 years ago now. And that order hasn't been contested and hasn't been revoked. The children continue to reside in Kansas. And as Your Honor said, like, California retained jurisdiction without prejudice during the course of the proceedings from January to June. And because jurisdiction was retained without prejudice, it was made clear to me by the judge in California that at the conclusion of the hearing in California in June, that I would then that I needed to re-request the transfer of jurisdiction so that any changes moving forward would be heard by the Kansas court. So the orders that you have in front of you are the current orders. The primary residence of the children remains in Kansas under the UCCJEA. I am requesting that jurisdiction be moved as it was the change of jurisdiction in California was denied without prejudice previously, and it was recommended to me to re-request. And that is what this request is. It is not necessarily a request to change orders in any way. The orders were just instated in California. It is to move the jurisdiction.
And Your Honor, the California court already made a decision on this. Well, the California court said that they would not release jurisdiction.
Okay, you kind of broke up there. Would you mind repeating what you just said?
Yeah, the California court made a decision on this situation because she had submitted paperwork.
Hold on. Monica claims California dropped the ball. She says Kansas already took emergency custody and issued an order, yet somehow California didn't file anything back in court.
Through the California court to release jurisdiction. And the judge said that she was not going to release jurisdiction in this situation.
Okay, and where does that say that in the order?
It doesn't say it, but that's what was stated in the court hearing. It is this court thing was put out in January, but we just had a court hearing this last time where Mr. O'Rourke was trying to remove jurisdiction or have the case released, and the judge said no.
Okay, let me just address Monica for a moment. Was this issue specifically raised at the conclusion of the California court proceedings that were recently held regarding the issue of jurisdiction from that point forward?
There were two separate filings. Mr. Hernandez had filed for a change in custody. The ruling on June 20th was regarding Mr. Hernandez's request for a change in custody. In those custody proceedings, I raised the change of jurisdiction for the UCCJEA. The judge informed me that she would not hear a change of jurisdiction request as part of a custody motion. So in the fall, I think in November or December, I filed a separate motion requesting a change in jurisdiction because the judge at that time said that I had to file it as a separate motion. And then that motion was heard separately. I believe the last hearing for that motion was possibly in December. I'm not sure. I was just as you guys were talking, I was just pulling up the minute order to review. And that motion, jurisdiction change in jurisdiction was denied without prejudice. And just for the sake of Mr. Hernandez, what that means is when a jurisdiction is denied without prejudice, it means that it can be requested again. And she specifically said, I'm not going to allow the jurisdiction to change until the conclusion of this trial. I'm doing this without prejudice with the intent that you are able to, at the conclusion of this hearing, if the children's residence remains in Kansas, to re-request a change in jurisdiction. And I am going to find on
All
my.
right, that is at least consistent with the discussions that I had with Judge D'Alessandro when this discussion was held regarding the two states possibly having jurisdiction at the same time. That Judge D'Alessandro wanted to see the matter that was essentially teed up for trial in California complete before there was any change in jurisdiction to Kansas. There was never an intention expressed, from my memory, that it would be forever. But certainly it would take us through this trial. And you went to trial, issues were decided by the California court. And of course, then we still have this lingering issue then of what happens from here regarding the issue of child custody jurisdiction. Kansas has a basis for child custody jurisdiction, but so does California. So I would have preferred that jurisdictional issue have been decided as one of the issues reflected by the journal entry, which is attached to the current motion. It doesn't appear to address it.
It does not. The judge in California was very clear that she would not address jurisdiction as part of a custody motion.
So is that set for a separate hearing?
It is not. I am requesting here, as this is their home state, with the intent for a subsequent, as was done before, a judicial conference between the courts to determine the issue of jurisdiction change.
Hey, Your Honor.
Yes, sir.
Yeah, I don't, in my opinion, I understand the legality of all this situation, and I understand that Ms. O'Rourke has, possibly has some sort of right to move the jurisdiction of the situation. But I just don't, in the best interest of my children, of our children, I don't think it's in the best interest of our kids to have jurisdiction moved to Kansas. Like I told you before, and I keep on saying this.
Things heat up fast. Mr. Bravo Hernandez finally steps in and doesn't hold back. He's furious that he wasn't told about the Kansas hearing.
In a lot of ways, this has been a hijacking move for Ms. O'Rourke to use the legal system to attempt to remove the kids out of my life. And I'm asking for the Kansas court to release this situation and not be involved. Allow the California court to continue to take over the situation or be in control of it, because I feel like the judge that has been involved in this situation, she's more aware of some of the things that have gone on. And I feel like if we move to the Kansas jurisdiction, I feel like this is going to start the situation all over again, and I'm going to be climbing.
And why do you feel that way? I'm not sure I understand. Why do you feel like just simply moving jurisdiction to Kansas and therefore child custody enforcement to Kansas, why that would be adverse to your interests?
Because I like the court, the judge was familiar with the situation, so I feel like starting all over again. Mr. O'Rourke would definitely have a foot above me. I don't know what the Kansas court is like, but I lived in Kansas and I lived in Wichita for about 6 years, and I'm not stating that this would be an issue, but I don't feel like I would get a fair trial in Kansas compared to what I'm getting in California. I feel like the judge here is more. She understands the situation. She has a lot of background, and the California court has a self-help center where I'm able to access that help. I haven't seen anything on the Kansas court system that where I can go and talk to somebody, and so uh, like just having access to that is more helpful for me than having to go through the Kansas court. Like I'm not in Kansas. If I have to pay for an attorney, that's going to be really impossible for me. I'm already paying child support to Miss O'Rourke. So this is more of a situation where it's going to be hard for me to maneuver legally. And I'm hoping that it doesn't go to the Kansas court because it just creates all kinds of hurdles for me, to be honest with you.
Well, I'll try not to take offense about your assertion that you believe that you can't get a fair hearing in the state of Kansas.
Well,
I would tend to disagree.
It's not that I'm not going to get a fair hearing. That's probably the inappropriate words to use, but I just don't yes, in terms of the situation, Mr. O'Rourke is in Kansas and I'm in California. I just don't feel like most people in the Midwest don't see Californians as in good standing, and I just don't feel like I have a good. I have like an uphill climb if we go to Kansas first. That's what I'm kind of thinking.
I understand, but I can also understand Monica's position that's been stated all along, that she was granted a move away order by the state of California. She established a new home state for the children here in Kansas, which takes at least 6 months of continued residency. And then once that threshold was met, then she sought relief from the Kansas courts, which to this point, this Kansas court has pretty much denied. After my conference, as I'm required to do under the UCCJEA, I conferred with a California judge in the domestic department in your county and determined that they should complete the trial that was held out there. But that doesn't necessarily mean that it wouldn't be appropriate at some point in the future for Kansas to decide issues regarding Kansas kids. You can assert all you want that they remain California kids forever, but the reality is they live here, they go to school here, and the people that most likely would be able to provide input to this court regarding their welfare are local. So I think Monica would certainly be of the point of view that she's not sure that she can get fairness from the state of California, and rather seeks that from this state. And I can understand both of your positions. And I understand your position, sir.
Hey,
Monica, you had something else you wanted to address the court about?
Yeah, I do just want to give this court the information that the assertion that the California court or any particular judge in California has the entirety of the facts of this case is not accurate. We have had 8 different judges hear this case. The current judge that just made this determination, this was the first motion that this particular judge heard in this case. The move away order was granted by Judge Luna. The restraining order was granted by Judge Guerra. There were 2 separate contempt cases. Both contempt cases were heard by 2 separate judges. There was an ex parte hearing that was heard by.
Now the judge leans in. She questions whether Kansas had the right to jump in before California backed out, and whether Hernandez was ever given a fair shot to respond.
An additional judge, and in addition to the actual divorce judge. I think that's 8, it may be 7, trying to count. So we have had a different judge for every single motion. The nature of the court in California, and this is what I believe, and I would like to bring the focus back to what is to the kids and who is able to hear what is happening with the kids, is the reality is that the way the California court is structured, there is never a judge that follows a custody case for all the motions that are involved in that custody case throughout the course of the case. Instead, the structure of it, from what I have experienced and from what I have when I inquired to my lawyer, the way that it works is each different type of case has a different bench. So when there is domestic violence involved, that gets heard over here. When there's just custody, that gets heard over here. When there's an emergency order, that gets heard over here. When contempt charges are filed, it gets heard in a different place. And so has never been, there still is not a single judge that has the facts of this case. And that is part of why I believe it is in the best interest of the kids to have the jurisdiction moved to Kansas, because from what I understand, just talking to people here, is that a judge is assigned to your case, and then that judge hears the case all the way through for any given motion involving the kids. And in that sense, outside of, I believe that Your Honor it would be my assumption that Your Honor would take the time to review some of the previous facts of the case via, supplemental declarations and the motions that were put in front of the court over the course of the last 7 years. Moving forward, I believe it is in the best interest to have a judge continually hear as the children get older, as circumstances change, and as their needs change, be able to continually hear the entirety of what's happening with the kids and be able to have the whole picture. The reality is there's never been a judge. The current judge that made the current orders, this was the first time that she has heard this case as a custody situation. Like I said, and it was Judge Luna did the move away order. This was Judge Hamilton. Judge Guerra did the restraining order. So it's always been separate judges.
How does your proposed parenting plan differ than what the California court ordered?
I do agree with Mr. Hernandez that it is very important for him to have regular interaction with the kids. The primary difference is that I'm requesting that interaction be in Kansas instead of placing the burden of travel on the kids to go to California. It would allow for Mr. Hernandez to continue to be involved in their lives as they exist here, being able to, like, for example, when he visits here, he's able to take them to soccer games. He's able to participate in their extracurricular activities that they have established here and support them here. And from what I understand, his primary argument for not visiting them in Kansas is not being able to get time off work. And part of my concern with them flying to California regularly is just that he's not able to get time off work. And then that leaves my kids missing out on all of their activities here in Kansas and sitting in California under the care of someone else, not him, missing out on time with him as well. And so if we were able to work with his work schedule and figure out times when he would be able to request time off work so that he would be able to have visits and be involved in the kids' lives that they have very well established here. They play national level club soccer now. So they're very, 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 very involved in soccer. They go to Andover Central. One of them goes to Andover Central, the other one goes to Andover Academy. They're involved in extracurricular activities there and music programs. And I just believe it's very important for him to be involved here. So that would be my primary request. And I understand that, I would assume that Your Honor would want to have more evidence presented, if you were to look at
The courtroom dives deeper into the kids' timeline and where they've really been. The judge wants clarity. Were they in Kansas long enough for jurisdiction to flip?
making a change to the California orders, my primary request is not necessarily changing the California orders. My primary and first request is to move jurisdiction here so that we can have a consistent judge be presiding over what's happening to the children for the next 7 years of their lives, so that there is someone that can address their changing needs. And, under the UCCJA, it says that the jurisdiction should reside in the place where the majority of evidence is, right? So they have family therapists, they have individual therapists here, their school officials, their teachers are here, their coaches, their friends, our neighbors. They have, their world is here primarily. The majority of the evidence for their well-being is here primarily.
All right. Benjamin, you've heard Monica's statements with some reaction, I note.
So we actually just went over this situation in court, and I brought witnesses to trial, and they stood up there and talked how their involvement in my son's lives has been really important. I just will note that none of Monica's family members showed up. It was all my family because my family's been involved in our son's lives. So what Mr. O'Rourke is attempting to do by moving jurisdiction to Kansas and reducing the visits to California, or not having them come out to California at all, is cutting the boys off, not only from me, but it's also cutting off their close relationships with my extended family, which in a way, to me, that is a form of emotional and mental health issues that I can't even imagine what Ben and Sam have gone through the last few years, because they've been taken out of people that are familiar to them and moved to Kansas, to a state where they don't have any family members involved. They have nothing but neighbors and people that are strangers to them. My brothers and sisters watched over Ben and Sam when they were younger, and the California court already went over this, the custody thing, and they determined that it's in the best interest of Ben and Sam to come out to California to continue those relationships with my family, because they have those close relationships. And that, like I said before, Monica is just attempting to reduce my ability to have access to our sons, and that's what she's going to continue to do, because she's not looking out for the interest of our boys. If she was looking out for the best interest of our boys, she would not have moved Ben and Sam to Kansas. That was an inappropriate move. I know the California court decided that was okay, but she declared that her dad was on a deathbed, and when I interviewed him on Zoom, he was picking up his prescriptions from some sort of pharmacy, or admitted to picking up medicine from a pharmacy, driving himself there, so he couldn't be on a deathbed. And I'm not really sure why the California court agreed to give her the move away order, but that's neither here nor there.
All right, since the order of child custody and parenting time, which issued from the state of California in June, does not appear, and I will review the order again, but I think if it doesn't address specifically relinquishment of California jurisdiction, it will be necessary for this court to once again confer with the judge that actually heard this case, which I think is Judge Jenny Hamilton, correct? Regarding her intentions regarding the retention of jurisdiction in a similar way that this court conferred with Judge D'Alessandro before the trial. So the court will take any ultimate decision regarding assertion of Kansas jurisdiction under advisement until that conference consistent with the UCC JEA has taken place. I think I will go ahead and set a review hearing date in this case when I have both parties on the meeting.
Your Honor, can you just review what you just said, like just re-explain it? I want to make sure I'm clear and understand what you're.
I'm going to talk to your trial judge in California
Okay.
and
And
reserve any decision on anything that you're currently moving this court for pending the outcome of that conference.
it is it is my understanding from my lawyer that, again, just having kind of giving you some insight into the situation about various benches within the family court system, it is my understanding that Judge Hamilton would not be, like, in any further motions, Judge Hamilton would not be the one hearing that motion. It would be my understanding that, you know, when I had messaged you and I said Judge D'Alessandro is our judge, we would be. It is my understanding that we would go back to the bench where Judge D'Alessandro is, not necessarily return to Judge Hamilton's bench. That she heard that motion for, she moved benches in the middle of our hearing. So she continued to finish out our hearing, but is no longer on the same bench that would hear a subsequent custody. So for what it's worth, I would guess, it is my understanding that Judge D'Alessandro is sitting on the bench where we would be at again. But again, just also understanding that there is no consistency in who hears cases in California.
So noted. I have no doubt that if Judge Hamilton believes that she's not the appropriate one to talk to, that judge will inform me of that.
Right. Just, yeah, it's very confusing.
All right. Again, regarding another date to review this case. And as always, my assistant may veto any date that I suggest. But I'm currently looking at August 21. And again, in Central Time, I'm looking at 1:15 for the conference time. Mandy, will that work?
That will work.
1:15, Thursday, August 21. It'll be done by Zoom, similar to today. And I will attempt to get my conferring done between now and then.
Thank you, Your Honor.
August 21, 1:15. Until then, I just want to make sure that it's understood that whatever orders currently exist in the California court are to be followed.
Yes, Your Honor.
All right. And we'll see you in August. Thank you both for your input today.
All right, have a
Thank
good
you,
one.
Your Honor.
If there's nothing further at this time, this matter will currently be in recess. This meeting may be ended for all.
Thank you, sir.
This is the moment of reckoning. The judge rules California will stay in control for now, but warns Monica that if Kansas wants it again, she better notify Hernandez. Clear deadlines, legal warnings, and one final chance to do it right.